Greetings.
Good morning, all.
Good morning, Judge.
Morning.
Good morning, Your Honor.
Good morning.
Good morning.
My name is Judge Jim Crouch. I'm a retired senior judge sitting by assignment pursuant to section 74.056 of the Texas Government Code to the Kinney County Court of Kinney County, Texas, for the Honorable Judge John Paul Schuster of Kinney County. This is a judicial matter being heard via Zoom pursuant to the Supreme Court miscellaneous docket number 23.9025, renewed emergency order regarding indigent defense and the border security state of disaster, and being broadcast live over YouTube to comply with the requirements of open courts and the guidelines set by the Office of Court Administration. Nothing about this broadcast changes Texas law. That is to say, it is illegal to record or photograph this proceeding without the consent of the court, and that consent is not given. The only official record of this proceeding will be by our court reporter today, Julie Campbell. Please be mindful that electronic hearings can be more taxing on the court reporter, so it is important that we do not speak over each other. If counsel makes a legal objection, whoever is speaking, please stop talking so the court can rule on the objection. We have begun the live stream over YouTube. Our interpreter today is Vicki Jones.
Judge, she's not connected to audio. I'm trying to get a hold of her.
Okay. We can't hear you, Miss Jones.
There you go. Now you can hear me.
All right, now we're cooking.
Good morning, Judge.
Good morning, Miss Jones. You doing okay today?
Doing great. Thank you.
If you'll raise your right hand, I will swear you in. Do you solemnly swear or affirm that you will truly, fairly, accurately, and impartially make a true translation of the statements of these proceedings presented before this court to the best of your knowledge and ability, so help you God?
I do, Your Honor.
And at this time, if you would please go ahead and give the instructions to our Spanish speakers online and let them know about the language line. I would appreciate that.
Thank you. Of course, for those of you who are listening in English, in a minute, you're going to have to select the English channel. Buenos días para aquellos de ustedes que necesitan escuchar su caso en español. En un momento, el juez va a prender un botón y ustedes van a tener que escoger el canal de español. Para llegar a eso, en su teléfono van a tener que tocar la pantalla, mover la pantalla y buscar los tres puntitos. Tocar los tres puntitos, ahí les va a salir una lista. En esa lista va a decir algo que dice interpretación o lenguaje. Tocan interpretación. Ahí le sale otra lista donde puede escoger español o inglés. Usted va a escoger español. Son tres pasos, tres puntitos, lenguaje y español. Y para aprender y apagar su micrófono puede usar el asterisco 6. Voy a escribirlo ahorita en el chat. Pero we can go ahead, Your Honor, and turn the interpretation button.
Thank you. And those of you that haven't been online before, you need to choose your language, either English or Spanish at the bottom. Okay, I know that we have a few pleas and abstention, I believe, and we will try to go ahead and do those first. But actually, the first case there, 11658 CR, Hector Javier Garcia Mendez.
Yes, good morning, Your Honor. Ashley De La Garza with Texas Rio Grande Legal Aid here for Mr. Hector Garcia Mendez.
And this is going to be a plea and abstention, is that correct?
Yes, Your Honor.
Okay, the charge is criminal trespass, a class A misdemeanor. Could the state please recite the terms of the plea bargain agreement? Oh, wait. You're not, we can't hear you. Mr. Shaughnessy,
Got it? How about that?
there you go.
All right, super.
Thank
In
you.
cause number 11658 CR, the state of Texas versus Hector Javier Garcia Mendez, in exchange for a plea of guilty or no contest to a class A criminal trespass, the state would offer a 48-day jail sentence. No fine, no court costs. Actually, that's class B misdemeanor, Your Honor. Excuse me.
Okay, gonna be a lower to B, okay. And Ms. De La Garza, did the state accurately recite the terms of the plea bargain agreement, and was that agreement conveyed and agreed to you by your client?
Yes, Your Honor.
Do you have legal authority to act for the defendant in this proceeding?
Yes, Your Honor. He was represented by my co-counsel Ariel Yoon, but we did file a declaration on this case as well.
Okay. Did you have an opportunity to corroborate the identity of your client as the same person named in the complaint and information?
Yes, Your Honor.
Did you inform the defendant of their Padilla rights and possible immigration consequences?
Yes, Your Honor.
Do you believe your client is mentally competent to stand trial and was mentally competent when they signed the paperwork in connection with this plea?
Yes, Your Honor.
Do you attest that your client signed, initialed, and added his thumbprints to the plea and abstention documents, and that every purported signature, initials, and thumbprints are that of the defendant?
Yes, Your Honor.
Did you review and explain the plea and abstention documents with your client in Spanish and or with the assistance of an interpreter?
Yes, Your Honor, through an interpreter.
Do you believe your client understood the nature and consequences of his plea and understood everything contained in the written admonitions and entered the plea freely and voluntarily?
Yes, Your Honor.
And how does your client plead to the offense of criminal trespass, a class B misdemeanor?
No contest?
The court finds that counsel has the legal authority to enter this plea in open court and that there is a waiver of jury trial. Based upon the plea of no contest, on behalf of Hector Javier Garcia Mendez, I will find him guilty of the misdemeanor offense of criminal trespass, a class B misdemeanor, and sentence him in accordance with the plea bargain agreement to 48 days in jail, no fine, no court cost. Did I follow the plea bargain agreement as you understood it, Ms. De La Garza?
Yes,
Your Honor, I believe this calls for a $2,000 fine and $290 in court costs.
Oh, okay. I thought you said nothing earlier.
No, I might have misspoken, but that plea
Mr.
bargain.
No, sorry. Go
Go
ahead.
ahead.
I was just going to ask that, given that my client is indigent, that those fines and court costs be waived.
Well, if that was part of the plea bargain agreement, what was that part of the plea bargain agreement? $2,000 a fine, and how much did you say? $299?
$290.
$290 in court cost. Was that the plea bargain agreement?
In 1 second, Your Honor. Yes, Your Honor, that was part of the plea paperwork, but it is also my understanding that the court can waive the fines and court costs if the client is indigent at the time of sentencing.
Yes, but Mr. Shaughnessy, do you have a
Well, Your
stance
Honor,
on
we
that?
disagree with that. It was part of the plea bargain. It was entered into, and I'm not aware of a finding of indigency with respect to his current status.
And the court would agree with that at this time. If there's something that comes up later where there's a file document that the court could look at, but at this point, there's nothing. Your client's not here. I don't have any documents. That's what the law requires, that the court make a finding, and with no documents being found, I'm going to follow the plea bargain agreement of $2,000 fine with court cost of $290.
Okay,
Okay.
and Your Honor, just for the record, will the court take judicial notice of the prior indigency affidavit that was filed in order to appoint us on this case? That is in the court's record.
Okay, if it's in the court's record, I will take that into consideration, but I need to be able to make that determination today. Things could have changed easily from that time to today. And you made the plea bargain agreement with the state knowing that that's what the deal was. So,
Okay, Your Honor.
okay, I find the defendant has waived his right to appeal any of the issues that could have been raised as a result of his arrest for this offense. Is there anything further by either side?
Not from the state, Your Honor.
Nothing further at this time.
Do you have other cases on the docket, Ms. De La Garza?
No, Your Honor, this is my only case. May I be
Okay.
excused?
Yes, ma'am. Thank you.
I believe
four.
4 is a plea in absentia, Your Honor.
Yes, number 4, which is cause number 13921 CR, State of Texas versus Mauricio Garcia Perez.
Good morning, Your Honor. Eliana Esparza with NDS on behalf of Mr. Perez.
And would the state please recite the terms of the plea bargain agreement?
Yes, Your Honor. And cause number 13921 CR, the state of Texas versus Mauricio Garcia Perez, in exchange for a plea of guilty or no contest to a Class A criminal trespass, the state would offer the defendant a 17-day jail sentence with a $200 fine and $290 in court costs.
Counsel for the defense, did the state accurately recite the terms of the plea bargain agreement, and was that agreement conveyed and agreed to by your client?
Yes, Your Honor.
Do you have legal authority to act for the defendant in this proceeding?
Yes, Your Honor.
Did you have an opportunity to corroborate the identity of your client as the same person named in the complaint and information?
Yes, Your Honor.
Did you inform the defendant of their Padilla rights and possible immigration consequences?
Yes, Judge.
Do you believe your client is mentally competent to stand trial and was mentally competent when he signed the paperwork in connection with this plea?
Yes, Your Honor.
Do you attest that your client signed, initialed, and added his thumbprints to the plea and abstention documents, and that every purported signature, initials, and thumbprints are of the defendant?
Yes, Your Honor. But my client was out of custody at the time, so we agreed to put the thumbprints from the booking paper.
Yes. Did you review and explain the plea and abstention documents with your client in Spanish and or with the assistance of an interpreter?
Yes, Judge, in Spanish.
Do you believe your client understood the nature and consequences of his plea, understood everything contained in the written admonitions, and entered the plea freely and voluntarily?
Yes, Your Honor.
And please state how your client pleads to the charge.
Judge, we enter a plea of no contest.
The court finds that counsel has the legal authority to enter this plea in open court, and there is a valid waiver of jury trial based upon the plea of no contest on behalf of Mauricio Garcia Perez. I will find him guilty of the misdemeanor offense of criminal trespass, a Class A misdemeanor, sentence him in accordance with the plea bargain agreement to 17 days in jail, $200 fine, and court cost in the amount of $290. Ms. Esparza, have I followed the plea bargain agreement as you understood it?
Yes, Your Honor.
I find the defendant has waived his right to appeal any of the issues that could have been raised as a result of his arrest for this offense. Anything further by either side?
Not from the state, Your Honor.
Judge, we had filed a motion to withdraw KBS and reinstate bond for the purpose of satisfying the fine and court costs. Can we just verify if that has been signed?
If it hasn't been, Judge, I'll make sure that it's presented to you.
Okay. I was just gonna look.
The order has been signed.
It has been signed. Okay,
Yes.
there we go. Awesome.
Thank you, Judge. And that is my last case. May I be excused?
Yes, ma'am, Mrs. Sparza, have a good day.
You too. Thank you.
You bet. Number 5 was supposed to be a plea. Has everything been worked out about that, or?
No, Your Honor. So I am appearing on behalf of my client, Mr. Marquise Dennis, and as the previous counsel has stated, Mr. Dennis is declared indigent. My client, however, does have the amount for the fines that the prosecutor did say, which was $250. My client has that, but he does not have the amount for the court costs. And before the state will accept the plea, it is a requirement in all of these cases that they pay the fine and the court costs, which to me, it appears that there needs to be some type of separation of powers or something, because I don't understand how you are saying before you can accept the plea, you must have the fine and the court costs paid, but you in essence are kind of taking away the defendant's right to go before the court and ask the court to waive those court costs when he has been declared, when a defendant has been declared indigent, or to even have the court to consider any other factors. Once these defendants have been declared indigent, Your Honor, they are presumed to be indigent until the end of this case. So I do not understand how the prosecutor can use the idea of having the court costs paid when you are in essence creating an undue hardship for these clients.
Well, that's between you and the state on that end of it. What your plea bargain agreement is with them. I only accept or deny the plea bargain agreement.
Your Honor, this is Tony Hackabill for the state, and we have been through this discussion, Ms. Dixon and I, by email recently, but it is also an issue that has been addressed numerous times with other attorneys. And what the court just pointed out is that this is the result of a plea offer. The plea offer is accepted, and we expect that the counsel and the client will stick to the terms of the plea offer. If the counsel wishes to go to the judge or to the court for an open plea, that's an entirely different matter. When I've kept this in mind the entire time, when I make an offer and counsel has indicated it's accepted, we then send plea papers reflecting the terms of that offer and expect that there will be no change to the terms of those offer. If counsel wishes to then proceed, doesn't wish to accept the offer, or the client doesn't wish to accept the offer, they're more than welcome to proceed with an open plea before the court, and we can then argue our relative positions. But until then, when the offer is made and it's accepted, we expect that the terms of that offer to be followed, or we're going to urge the court to follow the terms of those offer, and without deviation. Otherwise, we just simply won't have plea bargains.
And I agree with you. They either accept your terms or they don't, and they want to do an open plea, that's a separate matter, and then it can be raised at that point. Your client wants to say something. I don't know if you want him to or not, Ms. Dixon. I see his hand raised there.
No, Your Honor, I do not. I
Okay.
would still, in response to what he has stated, yeah, I just don't see how it is allowed for the state to use court costs, because this should be assessed after the defendant has entered and there has been a judgment. So I don't understand how this can be used prior to where you're saying.
If that's one of the conditions of the plea bargain agreement, it's just like he said, you can do an open plea at any time. And there might be something worked out where part of the plea bargain agreement is it's going to be for so many days or whatever, and then we're going to let the judge decide on some other issue. But they've made a plea bargain offer to you and your client, and you either want to accept it or you don't. And it doesn't sound like you're ready to accept it today. And if not, then we'll give it the next court setting, I believe, which is the trial date.
Yeah,
Is that what you want?
so my client has entered into the chat and he has stated that he will, if the court will grant him a continuance, to come up with the continuance so that he can have the money to pay within a week. He will have the full amount for the fine and the court costs. That is why he raised his hand. I still believe and would like to put on the record that I believe that this creates an undue hardship that this court is continuing to ignore, or the state is continuing to ignore, for indigent clients or defendants. But
And
if the,
you put that clear on the record. You've made that clear what your stance is. But Mr. Hackabill, if we reset this case for a week, is the plea bargain offer that you have made to them still going to be out there if they're ready to plea in a week? I'll be here in a week, and if everything is ready, I could hear it in a week.
Yes, Your Honor, we have no objection to that.
Okay, we're going to reset this case for 1 week, which is the 20th. Is that right, Madison? I am here next Thursday, aren't I?
Yes, Your Honor, we have you for 7:20.
Okay, we're going to reset this for 7:20 at 9 a.m. by Zoom. So, Mr. Dennis, you need to be back on July the 20th at 9 a.m. and Ms. Dixon also.
thank you, Your Honor.
You bet. Okay, and Ms. Dixon, you're free to go, Mr. Dennis. Okay. Ms. Dixon, you also have number 7.
Your Honor, I apologize for interrupting, but something's been brought to my concern. I don't know if this isn't being interpreted in Spanish, but I explained the instructions to my client and he said he's on the Spanish channel and can't hear. It's just in English. So I jumped on the Spanish channel and he's correct. I didn't hear anything in Spanish for about the last 4 minutes.
Yes. That's correct. Correct.
Okay, I just wanted to make sure that was the case because he's on the Spanish channel and all he hears is English. Could that just be made known to those listening on the Spanish channel that they are on the correct channel?
Yes. Okay, very good. Very good. Thank you. Thank you for calling that to our attention. Okay.
Okay, I'll switch back to the Spanish channel just to make sure I can hear.
Okay, very good. Okay, Ms. Dixon, you have number 7 on there. I think there's also a felony charge with
Yes,
number
Your Honor.
number
yes.
7 and number 9. Is that correct?
Yes, Your Honor, they have felonies. Yes, Your Honor.
Okay, and are they in Kinney County also or another county?
They are there
In Kinney County?
in County.
Your
Okay.
Honor, I have number 7 on the docket, Mr. Locks.
Okay. Is there something that we need to do about his case today, Ms. Dixon?
No, Your Honor.
Okay. So the next setting for this case is a docket call, I believe, on September the 5th, an in-person docket call at 9 a.m. in Kinney County. And he's still in custody there, sounds like.
Yes, Your Honor.
You said you had number 7, Mr. Locks, is that right? At Briscoe?
Yes, Your Honor, that is correct.
Okay. But and what about number 9, Ms. Dixon? Is that person in custody?
Your Honor, number 9 is
Number 9, Your Honor, Robert Anthony Garcia?
Yes, ma'am.
that's
Oh,
Mr.
yes, he's
Icke's
also in our
client.
custody.
That's
Okay.
not my client, Your Honor. That's Mr. Icke's client.
Oh, I'm
No, no.
sorry.
Okay.
That's okay, Your Honor.
Okay, Mr. Ike?
Yes, Your Honor.
Yes. And my understanding is you don't need to do anything with this case either?
Yes, he has a pending felony. We intend to resolve both and run everything concurrent.
Okay, so the next court date for this one is September the 5th at 9 a.m. in-person hearing. So I just want to make sure you knew that. That's the only case you have, Mr. Ike, is that correct?
Yes, Your Honor.
Okay, you're free to go, Mr. Ike. Thank you.
Your
All
Honor,
right,
may I
thank
be excused as well?
Yes, ma'am, Ms. Dixon. Thank you.
Thank you so much, Your Honor. You
Is-
guys have a good day.
That's the only thing that Briscoe has?
Yes, Your Honor, correct.
Thank you, Ms. Garcia. You have a good day.
You do the same. Thank you, Your Honor.
Okay. We're gonna skip down to number 10. That one's supposed to be a plea also, which is 14091 CR, said Texas versus Luis Luciano Coriano. And I believe our attorney is Janie Thomas.
Good morning, Judge Janae Thomas, on behalf of the defendant, Mr. Louis Coriano. This is supposed to be a plea. I believe we've done everything we need to do. I just need to confirm that with the state.
It's a plea in absentia, is that correct?
Yes,
Okay, and the state's ready to proceed?
State's ready, Your Honor.
Okay. The charge is evading arrest or detention in Class A misdemeanor. The state would please recite the terms of the plea bargain agreement.
Yes, Your Honor. In cause number 14091 CR, the state of Texas versus Luciano Coriano to the offense of evading arrest, the state would offer a sentence of 10 days in custody, $750 fine, and $290 in court costs.
And Ms. Thomas, did the state accurately recite the terms of the plea bargain agreement, and was that the agreement conveyed and agreed to by your client?
yes, Your Honor. I just want to make sure it's on the record that the court cost and the fine have been paid already, so he doesn't have any outstanding costs.
Thank you. And do you have the legal authority to act for the defendant in this proceeding?
I do.
Did you have an opportunity to corroborate the identity of your client as the same person named in the complaint and information?
Yes, Your Honor.
Did you inform the defendant of their Padilla rights and possible immigration consequences?
Yes, Your Honor. And for the record, he's a U.S. citizen.
Oh, okay, great. Do you believe your client is mentally competent to stand trial and was mentally competent when he signed the paperwork in connection with this plea?
I do.
Do you attest that your client signed, initialed, and added his thumbprints to the plea and abstention documents, and that every purported signature, initials, and thumbprints are those of the defendant?
Yes, Your Honor.
Now, is your client a Spanish speaker or an English speaker?
He speaks English.
English, okay. And you reviewed the plea and abstention documents with him?
I did.
Do you believe your client understood the nature and consequences of his plea and understood everything contained in the written admonitions and entered the plea freely and voluntarily?
I do.
And to this charge of evading arrest or detention, how does your client plead?
A no contest, Your Honor.
The court finds that counsel has the legal authority to enter this plea in open court, and there's a valid waiver of jury trial based upon the plea of no contest on behalf of Luis Luciano Coriano. I find him guilty of the misdemeanor offense of evading arrest or detention in Class A misdemeanor, and sentence him in accordance with the plea bargain agreement to 10 days in jail, together with a $750 fine and court cost of $290. Ms. Thomas, have I followed the plea bargain agreement as you understood it?
Yes, Your Honor.
I find the defendant has waived his right to appeal any of the issues that could have been raised as a result of his arrest for this offense. Anything further by either side?
Nothing from the defense.
And is this the only case you have on the docket, Ms. Thomas?
Yes, Your Honor.
You're free to go. Thank you, ma'am.
Thank you. Have a good day.
You too. Okay, let's go back to number 3, which is 12368 CR, State of Texas versus Jose Ivan Ayala Gonzalez.
Good morning, Your Honor. That's my case. For some reason, my client still can't hear. He's saying that he's not been given a Spanish selection, so I was gonna try and like copy and paste like pictures to see what he's seeing and to see if I can get him on there.
We can, what I was going to say was we can always go off the language line for this one.
Could we do that? It would just be this one.
Sure, yes.
You don't have to go off the language line, Your Honor. I have my second computer.
All right.
So let me see. I am here on the English.
You're a marvel, Ms. Jones. Thank you.
Thank you, sir. Okay, so we'll do consecutive on this one. El señor José Iván Ayala González, ¿me escucha? Prende su micrófono con asterisco 6.
Sí,
¿Me escucha?
sí, la escucho.
Bien.
Sí.
Okay, he can hear me now, Your Honor.
Okay. And you are Jose Ivan Ayala Gonzalez, is that correct, sir?
¿Es su nombre José Iván Ayala González, caballero?
Sí.
Yes.
And Ms. Starling, is there anything that we need to hear today about this case?
Yes, Your Honor. So I actually think this is the first time I've been in court with my client. Last time he had court, I believe it was June 8th, and I was sick. And for some reason, even though he was arrested in February 2022, I think this is the very first time we've appeared together. I did file a writ on his behalf on December 22nd, 2022.
May
And
I
that-
interpret, please?
Oh, sorry.
And when was that? The read was when?
December 22nd, 2022.
Thank you. Muy bien, señorita Starling. ¿Hay algo que usted quiera que se escuche ante esta corte el día de hoy? Sí, su señoría. Creo que es la primera vez que mi cliente y yo estamos juntos en la misma corte, porque él estuvo presente en junio 8, pero yo estaba enferma y no pude comparecer. Y aun cuando este caso empezó desde febrero 20 del 2022, nunca habíamos tenido la oportunidad de estar juntos en la misma corte. Yo presenté una orden que para que fuera escuchada la presenté el 22 de diciembre del 2022. Yes, ma'am.
And
Just a second, let me pull that up. You said that you filed that on the 20th of December, is that correct?
the 20th or the 22nd.
El 20 o 22 de diciembre.
Judge, it was
the
the 20th.
Yes, I'm just pulling it up just a second. I'm good. So this is basically an equal protection claim, is that correct?
Yes, Your Honor, since Mr. Aya Gonzalez was arrested in early 2022.
Okay, and have you filed a request to have it heard?
I'll pause for interpretation.
Muy bien, y esta es una orden que usted estaba solicitando por protección de igualdad, sí, su señoría, y ha presentado usted una moción para que esta petición de usted sea escuchada.
I realized last night that I hadn't done that, and so I filed one this morning as well as filling out the request form.
Anoche me di cuenta que no estaba, entonces esta mañana yo presenté una petición y también presenté las formas necesarias.
Since that has been done, then it will be sent to Judge
Reed.
Thank you. My mind was gone. Judge Reed to hear that. So we will not need to do anything else on this one today.
Your Honor,
Muy bien,
my
como ya
case-
se hizo eso, entonces esa moción se va a mandar a la juez Reed, quien ella la leerá, por lo que en este momento, el día de hoy, no tendremos nada más que hacer. Sorry.
Your Honor, my concern is that the next setting for this client is the in-person docket call on September 5th. And since the fourth court has been very clear about this issue needing to be taken up before in-person appearances are required, I would ask for another pretrial setting before that to ensure that this route has been considered before the in-person setting.
Su señoría,
Oh, go ahead.
disculpe, su señoría, lo que me preocupa de este caso es que la siguiente fecha que mi cliente tiene para regresar es en persona en septiembre 5, y debido a que todos los requerimientos se tienen que hacer antes de las fechas de las audiencias de juicio, yo lo que quiero solicitar es que me dé otra fecha para regresar para una audiencia antes del juicio para que se pueda hacer todo esto.
And Madison, could we get this a court date, maybe around the 20th or somewhere around August, kind of pretty late in August, to see where we are at?
Le pregunto a la señorita secretaria si tenemos alguna fecha a finales de agosto o alrededor del 20 de agosto. Están checando.
Your Honor, will August 17th work?
Yes, that's over a month. And so we would at least know that Judge Reed had accepted it and where we're at that point. So let's reset this until August the 17th.
Su señoría, agosto 17, ¿le parece bien? Sí, porque eso nos da más de un mes. Así la otra juez la juez Reed tendrá tiempo de haberla visto y aceptado, por lo que La fecha siguiente que usted tendrá que regresar va a ser el 17 de agosto.
So, Mr. Gonzalez, you need to be back online on August the 17th at 9 a.m.
Señor González, usted tiene que regresar en línea agosto 17 a las 9 de la mañana.
And Your Honor, I had one more concern I wanted to address. When I was looking at iDocket, I saw that there's an amended information, but when I go to open the file, it looks like it's the information file stamped on February 28th, and then like it's been written on and it's not file stamped again. And since it's not file stamped, I feel like it doesn't exist if it's not file stamped. And it's also not titled amended information. And so I'd ask the court to direct the state to actually file an amended information, because I'm not 100% sure what's supposed to be in there and what's not supposed to be in there.
Okay, there was an order signed.
Señoría,
Go ahead, I'm sorry.
I apologize. Su señoría, tengo otra preocupación. Otra preocupación porque como esto es una... Sorry about that. Como esta es una archivo, yo chequé en el iDocket y ahí está un archivo y este archivo está desde febrero 28, pero hay algo que se escribió ahí y no tiene la estampilla de la corte, por lo que yo siento que no está presentada, especialmente con la información enmendada de título, por lo que yo le estoy pidiendo al Estado que el Estado sea quien presente esta forma como debe ser con ese título.
Your Honor, if the court
Wait,
wants.
Just one second, 1 second. Because clearly, Ms. Starling, in the judge's order, it states that the information filed in this cause and is hereby amended as set out in the state's proposed amended information, and that the amended information presented to the court is approved and is hereby substituted for the original information. So it's fine.
Okay, but that entry in docket, in iDocket, that amended information, that's not a real court filing, right? Because it's not file stamped.
Señorita Starling, aquí yo estoy leyéndolo y la orden dice que esto está así enmendado considerando la información de los cargos original presentada por el Estado y que las enmiendas, por lo tanto, en ese documento de la información de los cargos está autorizada, por lo que estamos en lo correcto. La señorita Starling pregunta si, debido a que no tiene la estampa, entonces es válida o no.
The entire document is stamped and stamped as June the 9th, 2023 at 11:34 a.m. So yes, it is.
I'm talking about the entry. You're talking about the entry.
I'm sorry.
That's...
Ese archivo, todo el archivo tiene la estampilla de junio 9 del 2023 a las 11:30 de la mañana. Entonces sí está con la estampilla y todo está correcto.
I'm sorry, Your Honor. I just want to make sure we're on the same page. So there's an entry titled amended information on June 20th. And that's the one I had the concern about, because it's file stamped for February 28th and it's just written on, but there's no additional file stamp. But I don't know why it's on in iDocket if it's never been actually filed.
Pero la que me preocupa, mi señoría, es el que tiene la fecha de junio 20, porque ese tiene la estampilla de febrero 28, pero está escrita y no está la estampilla en realidad. Esta es la que me preocupa, mi señoría.
The clerk has to accept anything that's given to them, but that looks like the original information because it goes back to February. And even if that's filed in there, what Judge Garcia signed later supersedes that. I mean, or overrides that, excuse me. So
Okay,
it
so
clearly states that the new information is the one that Judge Garcia has approved.
okay, perfect. I just wanted to make sure I knew which information to go off of. So I'm gonna go off of the one Judge Garcia approved, not the one titled in iDocket amended information.
Your Honor, could I comment on that?
Okay,
Interpreter has to.
yes, let's let the interpreter do part first.
Ok, el juez dice, bueno, como el original es que ahí los clientes, las secretarias tienen que aceptar cualquier información que ellas reciban y como el juez García ya lo presentó, por lo tanto, eso es válido. Ok, entonces dice la señorita abogada, ok, entonces yo tengo que ver esa aún cuando no tenga la estampilla actual. El Estado quiere decir algo. Thank you.
And is the issue, Mr. Huckabee, Mr. Shaughnessy, sorry, that
I think Mr. Huckabee wants to weigh in, Your Honor.
okay, but is the issue that the clerk's office has not put a new file stamp on the amended information? Is that what?
Well, it's a little unusual that the particular information that has handwriting on it where the new language is interlineated, the fact that it is not file marked is a little unusual to me. That can be corrected by the clerk's office. But what I wanted to point out to the court is that we believe the law to be, and we were previously instructed by another court when we first started doing these amended informations about a year ago, that if in fact the court granted our motion to amend or motion for leave to amend with the example that was attached to that motion, then we were required and we were instructed to take the original information that was filed and to make the corrections on the original information on the original document. Now, why that is not file marked, I have no idea, but we've been engaged in that practice now for well over a year, Judge.
Okay. And what I will do is just instruct the clerk's office, just so there's no confusion, to go ahead and file stamp or file mark what was filed on, what's that date? June the 20th. That way there won't be any confusion. I'm guessing whoever accepted it from the clerk's office saw the other stamp at the bottom, and that was just an error on their part not to restamp it, because it should have been restamped whatever was filed. So I'm going to instruct our clerk. That way it's clear for Ms. Starling and y'all, and then there's no confusion. So Tiffany, can you do that for us? Please make sure that's done.
Judge Ballard, Chaplain
Yes,
for the
Judge.
state.
Excuse me.
Oh, wait.
Interpreter needs to interpret, please.
Hang on just a minute.
Thank you. Okay. Where were we? Ok, el señor representante del Estado dice, bueno, la ley a nosotros nos dice y la corte, otra corte ya nos ha dado instrucciones desde el primer momento que nosotros empezamos con esto, desde hace ya tiempo, que se podía enmendar el documento de información original. Y si la corte ya ha aprobado esas mociones para enmendar, entonces debe tener la estampilla. Sin embargo, aparentemente ese es un caso un poco común que no ha sucedido. Entonces el juez dice, muy bien, yo le voy a dar instrucciones a la oficina de las secretarias para que le pongan la estampilla necesaria donde tiene que estar en el documento con la fecha que se había mencionado de junio. Y así ya no va a haber confusión y todo va a quedar claro si nosotros ponemos esa estampilla. Thank you.
Okay, and Tiffany, can that be done? Can you make sure that's done?
Yes, Judge.
Judge, may I?
Let's let our interpreters do that first.
Señorita Stephanie, esto se puede realizar, sí, su señoría, aquí lo podemos hacer en esta oficina.
Go ahead, Mr. Shapley.
Judge, I'm concerned that Ms. Starling misapprehends the law. The law is that if an amendment is if leave to amend is granted, then the state amends the original document on the face of the document. We are not filing a new information. The filing of the original information at the time of filing vests the court with jurisdiction. So this is not as if we're dismissing the original information and filing a brand new one. That's not what's taking place here. So this business about the file stamps, I don't know, I don't think is really appropriate for discussion. We are simply amending the face of the original document. That's how this works.
Yeah, go ahead, Ms. Jones. Wait.
Yes, Your Honor. Ok, su señoría, la ley establece que si se aprueba alguna de los documentos de información originales que tienen la estampilla, entonces ya no se tiene que volver a presentar otro nuevo documento, porque ese original documento tiene la jurisdicción, por lo que aquí no tenemos que estar hablando acerca de esas enmiendas que se han hecho en el documento original, ya que no se está presentando un nuevo documento, sino es el documento original que tiene enmiendas. Entonces, esta cuestión de las estampillas, en realidad, yo no creo que tenga que ser discutido en este momento, porque las enmiendas se hacen en el documento original del documento de los cargos.
Okay, but I think what we've asked to be done clears up any confusion.
Well, Judge.
Ok, pero eso se va a hacer para que se evite cualquier confusión. Gracias, su señoría.
Okay. Anything else, Ms. Darling?
No, Your Honor.
Okay. And Mr. Gonzalez, you're free to go.
Muy bien. ¿Algo más, señorita Starling? No, su señoría. Señor González, ya se puede retirar, es todo. Interpreter will go back to the Spanish channel.
Thank you. Okay, let's go down to number 8.
Did we finish with number 2, Your Honor? That's also Miss Starling.
It has a capias. It has an outstanding warrant. So we're not going to go to that one.
Good enough.
No. Okay, so you're free to go, Ms. Starling. I think that's all you have. So
Thank you, Your Honor.
you bet.
We're going to number 6, Your Honor.
Well, we're going to go to number 8. Because that's Mr. Mohammed has all the other ones.
Oh, yes.
Get rid of this number 8 first. Okay, number 8 is 14387 CR, State of Texas versus Julio Cesar Araza Moya.
Good morning, Your Honor. Marissa Bodsley from NDS for Mr. Ariaza Moya. I don't expect him to be present. He is still in an ICE detention center, and I sent over information about that to the county attorney.
Okay, he's in ICE. Okay. So there's nothing we need to do about this one today.
No, Your Honor, nothing we can do right now.
Okay, is anything from the state?
No, Your Honor.
Okay, thank you. You're free to go, Ms. Bosley. Thank you.
Thank you, Your Honor.
Okay, there was one more that was on, it's an add-on, 14216 CR Giovanni Fernandez. Mr. Fernandez, are you online?
Hello, sir.
Yes.
I had a quick question. I was trying to retain my lawyer this morning and the payments hadn't gone through, so he couldn't represent me today. I was gonna ask if I could get an extension, like for 2 weeks, to make sure that it gets through.
Okay, and what's the name of the attorney that you're hiring?
Dunman Jones or Dunham Jones.
Dunham and Jones attorneys in San Antonio.
And they're in San Antonio, you said?
Yes, sir.
Do you have a phone number for them that we could give to our coordinator?
210-967-5264. And his name's Chris. Talk to Chris.
Chris is the attorney?
Yes.
Yes.
What's his last name?
I don't have the last name,
I think
but
Jones.
Jones.
Yeah, I think it's Chris Jones.
Chris Jones? Okay.
Yes.
And we'll have our coordinator try to call also, but we will reset it for 2 weeks. Is that a good date if we set it for 2 weeks, Madison?
Yes, sir.
No, not you.
Oh, my
Sorry.
bad.
Your Honor, we can put him on the 27th.
27th, we'll reset it to July 27th at 9 a.m. It will be by Zoom also. And hopefully you will have your payments done and we'll have your attorney present or online at that time.
Yes, sir. Thank you.
Okay. And you might tell your attorney, once you get the payments there, you know, give him the numbers there in Kinney County to call. You have those, is that correct?
Yes, sir.
And he needs to speak with Madison Rojas.
Madison Rojas.
Yes.
Okay. Thank
Yes,
you.
Your Honor. They have my email, so if they could give my email to him, and then on my signature, it has my office number, so if they could give that to him as well.
Can you do that,
Yes.
Mr. Fernandez?
Yes, sir. I
Okay.
have the information.
Okay, very good. You're free to go. Thank you, sir.
All right. Thank you.
Your Honor,
Yes.
I just wanted to clarify for the court that that was a write-in and that was that'll be considered number 14, and his cause number is 14216 CR.
Yes.
Giovanni Fernandez. His charge is evading arrest.
Okay. Now we're down to number 6. I believe 6, 11, 12, and 13 all fall out of or co-companion cases in a sense, co-defendants, all the rest of it at the same time. Mr. Muhammad, are you online?
Good morning, Your Honor. I am present. I believe my defendants, my clients are present as well.
Okay.
Together with, I believe they're all with Mr. Jonathan Hernandez Garcia.
Okay. First of all, we'll call number 14332 CR Jonathan Manuel Garcia Escalante. Mr. Escalante, are you online?
Let the record reflect he raised his hand, Your Honor.
Okay. And then the next one is 14333 CR Ariela Garcia Escalante. Is he present? If he's there, he needs to be on screen so we can see him right now.
He's not present, Your Honor. I would submit to the court that
no está presente, Aurelio.
Your Honor, I would submit to the court that when the docket came out, only Mr. Jonathan Garcia Escalante was on the docket. I informed him that only he had to be present and the others did not have to be present because he was the only one listed on the docket. Yesterday, the new docket came out and we reached out to them to let them know that they had now been added to the docket, so they couldn't be here. So I'd ask that his presence be waived for the purpose of this hearing, given the lack of notice.
Okay, well, I'm not going to wait. I mean, if it wasn't on the docket, that's one thing, but we're not going to hear anything in his case if he's not present. That's the problem. I'm not going to hear any pretrial matters without the defendant being present. Let me see if the other ones are online here. 14334 CR Edgar Alejandro Hernandez Garcia. Is he present?
No está presente Edgar Alejandro.
He's not. Okay. And 14335 CR Francisco Urbina Rincanada. Is he present? You are present. Thank you, sir. Okay. My problem is I know that some of these issues are complex issues and they need to be heard at the same time, and you're representing all 4 of them.
Your Honor, I was present at the in-person hearing, and Judge Roberts ordered that all 4 of these cases be reset to this date.
My notes, I'm sorry, Your Honor, to respond. First, I want to make sure that I would object if more than one prosecutor is going to speak during this hearing. I've noticed that, they all kind of chime in, and most certainly the local rules only require only one person from each side to speak. If that's Mr. Hackerbill.
That's up to the court. How many people there can be multiple defense attorneys, there can be multiple prosecutors. That's up to the court. So I'll be the one that makes that determination. I appreciate the objection though.
Thank you, Your Honor.
Let me go back and look. I have the records here. Let me see what Judge Roberts, or if you just want to admit that, is that what she ordered?
No, what I was going to say is the notes that I wrote, Your Honor, was that the hearing was going to be on the 14th. I could have written that down incorrectly. But most certainly when the docket came out, I informed my clients of who had to be present and who did not have to be present. If
Judge Roberts ordered them to be here, they had to be here. Let me go look. That's what I'm going to do. I'm going to look at those notes because they've been sent to me, and I'm going to see what she ordered. That's what we will follow, is what the judge ordered.
Judge Ballard Sheffley for the state. This morning I filed a response to Mr. Mohammed's pleadings regarding today's date. And as an exhibit, I attached the court reporter's record of the July 6th hearing. So that is attached.
I've got that. That's what I'm looking at. Yeah, just hang on just a minute. Just give me a chance to look over that. The court clearly says that it's to be reset into the 13th, which is 1 week. So that was made very clear that all 4 clients were to be here today.
Understood, Your Honor. I most certainly my notes reflect the 14th. I wrote that down wrong. I did not have the benefit of the court's of the transcript. So that's my mistake. But all of these individuals have been present at every single hearing and including with respect to the in-person hearing, they all had requested the opportunity to be present via Zoom, which they couldn't be. So I understand that 2 of these gentlemen are not present today. I had informed them that they did not have court today because only Mr. Garcia Escalante, only Mr. Jonathan Garcia Escalante was on the docket. That was my error. And they just haven't had enough time to appear. They've always appeared. They'll continue to appear. So I would ask that to the extent they're not here today and the court wants to do all these at the same time, we give them another day or 2 to appear. If not, given that the issues in all of these cases are the same, I would ask in the interest of judicial economy to just address the issues now and apply it to all 4 defendants.
Okay. What I'm going to do at this point, and then I'll let Judge Roberts going to be here on the 19th. Is that correct, Madison?
Yes, Your Honor.
Okay. Since she initially started this and she ordered everybody to be back here today, I'm going to punt just a little bit. I'll be honest. And I'll let her make this decision. But she ordered them to be here, so I'm going to forfeit the bonds of Aurelio Garcia Escalante and Edgar Alejandro Hernandez Garcia. Those are cause numbers 14333CR, 14334CR. I will not sign those until the 19th. If Judge Roberts does not want them to be forfeited and she wants to hear everything all together, then I will honor that. Otherwise, if it was up to me, I'd be forfeiting those 2 bonds today. And that's what I'm saying I'm doing at this point is I want them to be called. They'll be forfeited. If Judge Roberts wants to change her mind and say that she didn't really mean for them to be here today, but clearly she ordered all of them to be here today. 2 of those people are not here today. And then if they are all online on next Wednesday, July the 19th at 9 a.m. All matters can be heard together. And she started hearing these matters a week ago anyway, so I think it's good for her to finish those off. And it's looking like she will be the judge that would hear the trials, or that's what the plan is, at least at this point.
Your Honor,
I'm sorry.
sorry, Judge, I did not mean to interrupt you.
No, go ahead. Go ahead.
Thank you. Just for the record, we would object. Obviously, these men have intended to be present. There was a mistake made by defense counsel, contributed to by the incorrect docket that was sent out, which was the basis for the notice and when the hearing was. And all four gentlemen will be present on I'm sorry, Judge, can you just tell me the date one more time? Because I want to make sure I wrote it down correctly.
It's July the 19th at 9 a.m. That's next Wednesday.
Thank you, Judge. All gentlemen will be present on July 19th at 9 a.m. They've been present for each and every one of their hearings. So we would object to any type of gotcha, bond forfeitures, or anything like that.
Well, there's no gotchas. I don't know why you would say that. Just following the law. Okay. Okay. So I think Ms. Jones, you can tell the clients, I want to make sure you tell them that they need to be back on July the 19th, Wednesday at 9 a.m. by Zoom. Thank you, Ms. Jones. Okay, and I believe we're finished with those for this morning. And these were the only four you had. Is that correct, Mr. Muhammad?
Yes, Your Honor.
Okay, thank you. You have a great day.
Thank you, Judge. You have a good day.
You too. Okay, I believe that's everything on our docket. Is that correct, Madison?
Yes, Your Honor, as far as I know.
Okay. We're gonna go offline. Except for everybody but Madison, and I'll be here. So good day to everybody else. Thank you. Thank you,
Judge.
Thank you, Ms. Jones in particular, and thank you, our court reporter, Ms. Campbell.
Yes, sir. Have a good day.
You too. Thank you.
Thank you, Judge.
Thank you.